Good morning, Mr. Patterson. Can you see and hear me okay?
Yes, I can, Judge.
Okay, Ms. Cunningham, can you see and hear me as well? Okay. All
Yes,
right.
I can. Thank you.
All right. So I'm gonna just ask for your patience. The criminal district attorney says that she wants to be a part of this case, and she's not here. She's expecting maybe 9:30 is the earliest that she can be here. So I wanted to advise you of that and ask if you would just be patient with me. And what I'll do is I'll put you back in the waiting room. As soon as she gets here, I will bring you all back into the hearing. Don't mean to disrupt your workday any more than we already have.
That's all right. No problem.
All right. Well, I appreciate that, and I'll bring you back in. And sir, can you pronounce your last name? Is it Iwa? I'm sorry, you're muted, sir. I try to read your list, but I'm really going to mess up your name.
Ijua.
Ijuwa. Well, that's okay. That's phonetic. That's easy enough. All right, Mr. Ijuwa. Okay, so I'll put y'all back into the waiting room, and I'll bring you in as soon as I can.
All right, thank you, sir.
Thank you very much for your patience. I appreciate you. All right, the court's going to call this morning's docket. When I say your name, please say present or here. Raise your hand so I can acknowledge you for the docket. Jennifer Gathright, Kelly Gathright. All right, Mr. Brown, Justin Harrell. Justin Williams. Grace Fowler. And Mr. Bruner is in jail. Is that correct? Where is Miss?
Mr. Bruner is.
Yeah, so he said at 10, but I think that's because we had Dr. Ingram to be here at 10. So, okay. All right, out of the names that I've called, State, can you tell me who we're having contested hearings on today?
Your Honor, this morning, the state has filed a motion in Mr. Carroll's case. Mr. Sanders, I think we would get a set in another county. He's going to be taking late on that. I know the state has an agreement with Mr. Williams. I believe other than those, everything else is going to be at 10 o'clock with Dr.
So Justin Williams with Mr. Sminner is going to be what, a plea?
It's an agreed, it's an extension.
And then, Your Honor, President Catherine, the state has considered work prepared, however, I
Mr. and Miss Gathright, have y'all spoken with your attorney? Is he en route? Do you know? Can you step out in the hallway and give him a call and give me a estimated time he may be here? Thank you. And you've said Mr. Sanders is running late.
Judge, I will call correctly.
Mr. Schmidt, do you have any cases on the docket? Mhm. All right, court calls, cause number CR 2178, CR 2179, State versus Daniel Scott Larsey. We're set today on motion to suppress on cause number 78, and then docket call on cause number 79. Mr. Schmidt, did you have an announcement on your motion to suppress?
I did, Judge. Previously, we filed a motion to suppress. I've met with the state, gone over the evidence. At this time, we're withdrawing that motion to suppress.
All right, court will grant the motion to withdraw the motion to suppress. Court will set Mr. Larsey for a docket call, and you're out that week of December 14th and 16th, correct?
Yes, sir.
Mr. Larsey's in jail, is that correct?
Yes.
All right, court will set Mr. Larsey then for January 4th for docket call. And you're gonna communicate that to your client at the jail since we haven't had any brought over.
When I'm done here, I'm going to attempt to get into the jail.
Hopefully they will. If not, let me know.
Yeah.
Mr. Schooner, are you ready?
Yes, sir.
Cause number CR 2276, State versus Justin Wayne Williams. And what's the state's announcement on the motion to revoke?
State has agreement to withdraw, stand with amended conditions.
All right, Mr. Williams, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, Mr. Sminner, can you give me some reassurance as why the court should amend your client's community supervision?
Mr. Williams, took it upon himself to address some of these issues on his own without me or anyone else telling him. He entered into a rehab facility. He successfully completed that by the documents to the state. There's follow-up counseling that he's doing. He's also been attending NA meetings on an almost daily basis. So he's shown great effort to address these issues on his own. And he has established a support system that he feels very comfortable with. He's got a sponsor who he communicates regularly with, and he didn't want to disrupt what he's got going on his own. He feels like he's found a way to address his addiction issues and on his own succession. And so the state converted to probation, they recommend that he be continued and extended with intensive supervision and have his probation extended with additional 2 years. I believe that's not the community.
And do you believe your client will be able to comply with the intensive supervision requirements?
Yes, sir, I do.
You
He
understand?
seems very motivated to take care of this issue.
And has he spoken to the probation department about the requirements of that program, how often he has to report, things of that nature?
No, he has not. We discussed it when they gave us the amendment that he indicated that he's willing to do all of us.
So he believes he'll be able to report weekly?
Yes, sir.
All right, Mr. Williams. Has anyone threatened, forced, or pressured you to make you feel like you had to agree to the amendment of your community supervision? Do you believe that if the court approves this today, do you believe that that will increase your chances of being successful on probation? Can you tell me how you're addressing your drug addiction?
Well, I've been doing everything I can do on my own. You know, I mean, a regular NA group that I go to, like he was saying, at least 4 to 5 days a week. You know, if I can make it, I go every day. But some days, you know, I can't make it. But I went into treatment and fortunate enough to get into there. And I knew I needed it, and you know, doing some counseling and addiction. I have an addiction counselor and just working on it every day.
Can you tell me some things that you've learned in your treatment program and through your counseling?
Well, pretty much just I just have to keep calling my sponsor, and I have to the meetings work the best for me. I mean, I go in there and I just talk to other people, you know, with some kind of issues, and you know, I have 100 days clean today, so
That's good. Do you have triggers?
yeah, I do, and I'm avoiding those kind of things right now.
And what are they? What are your triggers?
Well, I used to, you know, be upset about things or whatever, and you know, have things that would I'd get maybe mad or whatever, and I'd go to abuse, and I just avoid those kind of things now. And I was I'm not saying it's anyone else's fault, but I was also in a bad relationship with another user, and I got out of that, and think, you know, we would fight sometimes and get into it and not abuse. So, and also stay out of, you know, I used to gamble and all that kind of stuff. Don't do it anymore. Those are triggers for me. You just being doing those kind of things. Just don't do it.
Well, I appreciate you sharing that with me. All right, so I believe that you know, people can beat an addiction. I know it's a lifelong thing that you're going to battle for the rest of your life. I know that, but I believe that you can overcome it with work and effort. It's not about luck, and it's not always, like you said, it's not about other people. It's about you, decisions you make, right? Choices you make. So I will, despite your allegations and your motion to revoke, I will approve the state's motion to withdraw its motion to adjudicate. I will approve the extension of your community supervision for a period of 2 years. I will order you to participate in the intensive supervision program and follow all other conditions on the current conditions that you have and the amendments that you have agreed to today. So I'm going to sign that, and I want you to report over here to Officer Matura, and she'll give you further information about the next step. Congratulations on your 100 days. Let's double that, and then let's double that and continue to double. You understand? All right, you come forward. Ms. Curry, are you ready? On Mr. Brown, Terrell State's ready. Yes, thank you, Mr. Spinner. All right, court calls, cause number CR 09382, matter of Jeremy Thomas Brown. This is a hearing on the request for outpatient treatment of Mr. Brown under Article 46C. And let me ask, is Miss Truth Toombs, is she a member of Terrell State Hospital? Should she be in this hearing? I see her in my waiting room. Does that name ring a bell to anyone there at Terrell State Hospital? Truth Toombs, TOOMBS.
Truth is going to be the case manager for his HCBS services.
Okay, so let me bring her in then. I wanted to make sure.
It's a male, though.
It's a male. Let me bring him in. And I appreciate that heads up.
Thank you.
Hi, judges. This is Dr. Dunn at Terrell State Hospital here with Jeremy Brown, and Chandra Vernon will be in here in a minute.
Okay, thank you, Dr. I appreciate it.
We'll go ahead and go on mute until you start back up.
Yes, sir. All right, court's going to proceed with this hearing. I just asked for appearances for the record. Ms. Curry, we'll begin with you.
Thank you, Your Honor. Tommy Curry, Criminal District Attorney for the state.
Mr. Pattison,
Richard Pattison on behalf of Jeremy Brown.
Ms. Cunningham,
Amy Cunningham, Director of ACT and OCR programs at Child and Family Guidance Center.
Mr. Ijua,
Provider agency, Compass Community Care for HCBS program.
okay. And Dr. Dunn, I can't list all of y'all on the screen here, but you could unmute and tell me who all is with you.
I'm Dr. Dunn. Mr. Brown, my left end.
Chandra Vernon, social worker.
I'm sorry, say your name again, ma'am.
Chandra Vernon, social worker.
Is that CHANDRA?
That's correct. And last name is spelled V as in Victor, ER, N as in Nancy, U, and then M as in Mary.
Thank you very much. I appreciate that. I'm gonna write that down. All right, and as I said before, this is a hearing on court-ordered outpatient or community-based treatment and supervision regarding Jeremy Thomas Brown. And Ms. Curry, do you want to proceed in this matter, or do you want to allow Dr. Dunn and the hospital to proceed?
I can just lay some background. For
Yes, if you'll go ahead, please. And if you cannot hear Ms. Curry, I know our microphone system is not working well. Just raise your hand and I can have her come closer to this microphone, okay? Go ahead, Ms. Curry.
Thank you, Judge. Previously, Your Honor, Mr. Brown was jury returned a verdict of not guilty by reason of insanity. He was then ordered under 46C or the predecessor to 46C to inpatient treatment after the court then made the appropriate findings regarding dangerousness to himself or to the community. At this point in time, Your Honor, I have reviewed the reports from Dr. Dunn and others at Terrell State Hospital where he is now, where Mr. Brown is now. They have concluded, Your Honor, that he is at this time does not meet the criteria for further inpatient treatment because they have presented evidence to the court that he is not a danger to the community or to himself at this point in time. We have no evidence, Your Honor, that would contradict that. In this particular case, it's been such a long period of time that the only evidence now is the reports of the doctors, which has been and no treatment records. So we have nothing to offer the court here other than the reports from Charles State Hospital.
Thank you. And Mr. Patterson?
Judge, I've been involved in this case for the past 11 years. I represented Mr. Brown at the beginning. He has worked very hard in the program. He's had a difficult time. He has never prematurely wanted to get out. In fact, he's asked to stay in several times over the years. So this is a very positive thing. I'm very happy that the board and the doctors and the treatment team all think he's appropriate. I spoke with him yesterday. He is excited about the prospect. He seems to understand the parameters of the program and is ready to move forward. And I hope the court will grant the request.
Thank you, Mr. Patterson. Dr. Dunn, do you want to give an overview of the hospital's position? And so obviously what I'm looking for and what I must hear today and approve is this, the whole treatment plan for the outpatient treatment to make sure that it complies with the code. So, and if you would rather pass that along to one of your colleagues, if you'll just let me know when it would be appropriate to do that, and then I can call on that individual for you.
I will, Your Honor. Oh, wait.
And yeah, go ahead.
Do you want to go and swear me in, Your Honor?
Yes, okay. I'll tell you what, if everyone that's going to testify will raise your right hands. Ms. Cunningham, are you going to testify? Mr. Ijua, if you'll raise your right hand. Do each of you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Dr. Dunn?
I do.
Ms. Vernum?
I do.
Ms. Cunningham?
I do.
Mr. Ijua? All right, you may put your hands down. Go ahead, Dr. Dunn.
Your Honor, I've been Mr. Brown's attending psychiatrist during the time that he's been at Terrell State Hospital for most of those times. And as you're aware, the offense occurred 12 years ago, when he was eventually found not guilty by reason of insanity on the charge of arson. When we first treated Mr. Brown, he was a quite young man, about 19 or 20, I believe, the first time we saw him. And he was very emotionally fragile, volatile in terms of his emotions, very sensitive to rejection, and exhibited a lot of self-abusive behaviors. These sometimes led to him causing significant damage to himself. Some cutting behavior, most concerning situation in which he broke a light bulb and stuck it into his neck, requiring a tracheostomy and emergency medical care. There were times when he would be very volatile in terms of his response to other patients and staff, although usually not particularly aggressive towards others. Most of the harm was towards himself. But he did require treatment in the maximum security facility in Vernon because of that self-abusive behavior and the fact that he was not really improving over time. He had subsequent hospitalization at Russ State Hospital as well, but eventually made his way back to us, I believe, in 2018. And although for that first year or so, he continued to be quite emotionally fragile and quite sensitive to rejection, he's had a significant improvement in those behaviors over the past year and a half. He's developed a greater capacity to modulate his responses. He's been able to tolerate frustration when others disappoint him. And when there have been situations in which previously he would have engaged in self-abuse behavior, he's used some of his self-soothing skills, including a significant capacity to draw that he's developed, to take that frustration and use that in a much more productive manner. During this whole time, I've told him that he was kind of in charge as to when he felt he might be able to get out, and we would be assessing that. But it was pretty evident initially that he was a little bit worried that we might try to push him out too early, and he would view that as rejection. So we've been very careful in working with Mr. Brown as a treatment team to make sure that we didn't move this process along too quickly. Now, 12 years is an incredibly long time. We obviously don't keep people in the system usually that long, but for Mr. Brown, it was evident that earlier on, he simply didn't have the capacity to tolerate frustration and rejection in a way that would have allowed him to be successful once he got out of the hospital. But we do think that now he's reached that point. Earlier in his hospitalization, there was a belief that he suffered from a psychotic illness similar to schizophrenia or a schizoaffective disorder, even bipolar disorder. But as we've come to know him, we've determined that his actual diagnosis is more appropriately defined as a post-traumatic stress disorder due to trauma he suffered as a youth and subsequent trauma, and also a borderline personality disorder. And people with borderline personality disorder frequently have difficulty with frustration, rejection, relationship with others, and that certainly would describe Mr. Brown, particularly in his earlier years, but he's developed a greater capacity to deal with those levels of frustration and greater capacity to interact appropriately with others. We also determined that he actually does not have a psychotic illness. What was described as psychosis before was likely those brief periods of panic and difficulty understanding some of the frustrations that he was dealing with, and he would externalize those as a voice rather than simply an impulse or an idea that he was having. So we've been able to simplify his medication regimen because of that determination with regard to the diagnosis. We've been able to work with him developing greater skills in terms of coping and engaging with others. And we do feel that now he has the capacity to safely function outside the hospital setting and in a supportive living environment. At this point, I'll turn that over to Chandra Verma, because she was the one who's worked on the outpatient management plan.
Okay, thank you.
Your Honor, would you like me to just provide an overview of the services he'll receive?
Yes, ma'am, please.
So he is eligible and has been accepted into the home and community-based adult mental health program. So he has participated in an individual recovery plan where he has elected nearly all of the services that that program provides. He will have supervised living at a group home where a staff will be available 24 hours a day. He'll receive nursing visits 3 times per week. He'll receive counseling twice per week. He'll have psychosocial rehab, which includes like life skills, budgeting. He'll have those opportunities twice per week. The HCBS provider will also assist with transportation for any needs he has. He'll have peer support once weekly, and they've discussed employment services a couple of times each week, although the plan is for him to not seek employment for at least 6 months to ensure that he's transitioning on an outpatient basis. In addition to the HCBS services, he'll receive psychiatric and case management through child and family guidance. And all of us collectively have discussed the services each provider will receive, or will provide, excuse me.
All right, and so what was the name of the community home center?
It's Compass Community Care, and Ede is the individual responsible over that program.
Okay, thank you. And with regards to the supervision that is required, or maybe not required, but can be ordered by the court in 46C, does the treatment team anticipate that he should be, or does the treatment team want him to be supervised by a correctional community supervision officer here to follow along with making sure that he's doing what he's supposed to do with regards to his treatment plan? Or do you anticipate that that's going to be provided by the Compass Community Care Group?
Right, I was not expecting that he would need a supervision by a correctional officer.
Okay. Well, and so under the law, it says that the court must identify, the person responsible for administering the ordered regimen of outpatient or community-based treatment. And it says the court, may order that the acquitted person be provided appropriate community supervision, by either facility administrator or of a community supervision and corrections department. So we believe that, are you telling me that under the plan that the facility administrator of the community center is going to provide that supervision, and they're going to report to the court if Mr. Brown is not following along with the requirements of his treatment? Is that correct?
Yes, Your Honor.
Okay, great. And can you give me the name of that individual again, Ms. Farnham?
Amy Cunningham is the one I predominantly coordinated with. although Mr. Brown is going to have a separate case manager who may be more likely to send in those reports.
All right, so there's going to be a case manager, and then Mr. Ijawa is going to be the community care supervisor. Is that correct?
The provider at the house, yes.
At the house. Okay, great. All right. So is that all you have for me, Ms. Farnham?
I believe so.
All right, Ms. Cunningham.
So I'm here just to answer any questions you might have about the ACT level services that he'll receive from Child and Family Guidance Center. He'll get at least monthly visits with his psychiatrist, the first one being within the first 7 days of discharge from the hospital. And then if it becomes clear to us that he needs more frequent visits, we will make that happen. So, and we also provide the prescriptions and work with the home and community-based services to ensure he has the medications and is taking them as prescribed. He'll also receive psychosocial rehabilitative services from a case manager who works on my team as well.
So you coordinate with Mr. Ijawa on making sure that he's in compliance, and if he fails to receive his medications or take his medications, you'll be also reporting that to Mr. Ijawa. Would you also be reporting that to the court, or just to Mr. Ijawa as the administrator?
If it depends on what makes the most sense logistically for everyone. If we want to just, for you all just to receive reports from one person, and we want that to be Mr. Ijawa, then I'm fine with that. We can just coordinate that way. We also historically with other clients have reported directly to the court. So we're comfortable with either.
What is the most commonplace practice on other community or outpatient community treatment plans like this? Is it for multiple people to be reporting, or for it to be funneled through one administrator?
I think Mr. Ijawa can answer that better than I can,
Okay.
I think.
George, normally, as Ms. Cunningham has stated, it normally comes through, the child and family. So one person, her agency has always been the one that does that reporting.
And Your Honor, this is Ms. Burnham. I would also recommend Child and Family Guidance provide that update, as home HCBS program is very participant driven. And if he would like to, he can terminate those services at any time. Whereas he should be mandated to have mental health services through Child and Family Guidance.
Okay, thank you. All right, and Mr. Ijawa, do you want to elaborate on what you'll be doing with Mr. Brown?
So the HCBS program has what is defined as supervised living. In the home that Mr. Brown will be residing is in City Hill. It's in a community right off of 67 in a very quiet subdivision. There are other residents in the home, so Mr. Brown will be one of the residents in the home. He will participate in group activity as far as meals. We provide 3 meals a day. They're not responsible for preparing meals, but if they so choose and want to participate in chores like doing dishes, cleaning up around the house, we encourage them to do that as part of their growth. Again, it's a single family home, and we provide nursing services that comes in there 3 times a week, to check on their vitals and also to make sure that their medication is being taken and that they don't have any adverse reaction to medication. We also manage all their other services, including, visitations by any family member that choose to do that. But also they go out, they have outings where, for those that want to participate in church services, we provide transportation for them. They visit the local stores like the Walmart, and, they go out, sometimes they will go watch movies as a group. And that's normally, coordinated through the psychosocial rehab caregiver that comes to the home to meet with the clients. So in this service, one of the things that we are very proud of is peer support. The peer support is very important, especially because, the provider has a lived experience and is able to relate to, people struggling with, mental illness. And so he would have that peer support person that comes in there, to meet with him. Now, as Ms. Cunningham stated earlier, we actually work very closely with Child and Family. In that same home, she has another service provider that comes in there to see all the clients in there. So he will be pretty much in a group where there are other people that are also receiving the same similar services from Child and Family.
Okay. All right, anything further from anyone? So, Mr. Brown, we've been talking a lot about you. We haven't talked to you yet. Do you want to say anything to Dr. Dunn or any of your treatment providers or Mr. Patterson?
I want to say to Dr. Dunn and also Sandra, how very thankful I am for me coming here and getting the treatment and care I received here, because it's made me into a new man, and I'm really happy to start this new chapter outside the hospital whenever it comes, hopefully soon. And also want to thank you and also everyone else for having this court meeting today, and for people believing in me and stuff like that. And with the HCBS program, I would like to stay in that program for a pretty good long time. Don't want to turn get out of it. I would like to stay in it. I'm really looking forward on learning how to what's the proper word for it? Learn how to be dependent on myself and not family, instead of going to live with family, that kind of things. So I'm excited.
Well, that's great to hear, Mr. Brown, and court is very pleased to hear all of this positive news. You spent quite some time trying to get to this point, and I know a lot of people have put a lot of effort and work into that, and you are included in that. And so I want to say I just want to commend you for your work and your patience and your understanding and putting forth that effort that you needed to there at Terrell State Hospital to give Dr. Dunn and all of the staff the ability to get you to this point. So if the court approves the community-based treatment plan, just to answer Mr. Brown's question, how long would it take for the transition to occur to get him outside of the hospital setting and into the community home?
I likely wouldn't need more than a day. If approved, maybe we could plan for a discharge next week, and then we can thoroughly review all of the details with Mr. Brown.
Okay, so it would happen pretty quickly then. Okay, all right. Is there anything further from any interested party?
No.
Okay, all right. Then based on the evidence presented to the court does find that it has received the community-based treatment plan for Mr. Brown, and the court does approve that treatment plan. Court also finds that the community-based treatment plan and the supervision therein will be provided to Mr. Brown, and the court, having made those findings, hereby approves all of the services and orders all of the services that are mandatory within that treatment plan to be administered to Mr. Brown. Obviously, any of the voluntary services, if he seeks to take advantage of those, he can. And likewise, if he does not, he doesn't have to. But on the recommendation of Ms. Varnum, the court will order those services previously mentioned to be a required part of the community-based treatment plan. And the court will request that the order identify Mr. Gade Ijawa as being the person responsible for administering the community-based treatment and supervision. And the court will order any person that has any concern or reason to believe that Mr. Brown is not following the supervision and treatment plan to report that to Mr. Ijawa, and then may likewise report that to the court individually if they so please, but want to make sure that that is being reported to Mr. Ijawa as the community-based supervisor. Ms. Curry, or let me ask, who would be able to assist the court with the provision of an order that outlines the rulings today and the requirements? Dr. Dunn, does the hospital have any access to any orders that are typically used in cases like these? Ms. Burnham?
We do not, Your Honor. We frequently work with Dallas County, and they have their own order that they often use, but the hospital doesn't provide them with the order. We might be able to ask some of our connections or liaison in Dallas County, or at the very least our liaison here with our courts, to send a copy of one of those orders to the court if you would like that, so that you can use that as a model or template for an order.
Yes, sir. If you would do that, I would be much appreciative. And Ms. Curry and Mr. Pattison, if you two want to get together and see if you can find one as well, then I want to make sure that we get it done.
That should be close to this situation.
Okay. Yeah, Dr. Dunn, if you will send that, then Ms. Curry says that she believes that she may have one, then we'll look to maybe merge those and get what we need for Mr. Brown so that we can expedite the transition for him into the community-based treatment program.
Yes, Your Honor.
All right. If there is nothing further, then we'll be adjourned. And Mr. Brown, I look forward to hearing more positive things about your transition and this new chapter that you're embarking on. Congratulations, sir.
Also want to say thank you very much. When you approved me, almost brought tears to my eyes, so I'm very happy.
Well, you're very welcome, and you're to be commended. You thank Dr. Dunn and the staff there. It's all of your hard work that's enabled me to do this. So, you're to be commended on the work that you put in, and just tell the staff how much you appreciate them working and helping you get to this point. And then let's just keep on improving from this point forward, and we'll look forward to maybe more hearings where we get just better reports for you, Mr. Brown.
Yes, sir.
All right. Well, if there's nothing further, then we'll be adjourned in this hearing. And Dr. Dunn, if you'll get that template sent to me from any of your contacts, and Ms. Curry and Mr. Pattison, then I'll get to that and give it attention quickly so that we can get it back to the hospital. Thank you all for joining me today. I appreciate it.
Thank you, George.
You're welcome. All right, this is cause number CR 21-117, State of Texas versus Jennifer Lee Gathright, and also cause number CR 21-118, State of Texas versus Kelly Wayne Gathright. Mr. and Ms. Gathright, if you'll each raise your right hands. Do each of you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hands down. All right, I'm going to start with you, Jennifer. Your name is Jennifer Lee Gathright, is that correct? And are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Heath Hyde. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all your questions answered? Is there anything about the paperwork that you've read and signed that you do not understand? All right, Mr. Gathright, same questions to you. Are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And you're also represented by Mr. Hyde. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all your questions answered? Is there anything about this paperwork that you've read and signed that you do not understand? All right, each of you have been charged with first-degree felony offenses of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 400 grams. The range of punishment for a first-degree felony is confinement in the Texas Department of Criminal Justice for not less than 5 years or more than 99 years or life, and a fine not to exceed $10,000. Do you understand that range of punishment? That means if the court approves this agreement today, any agreement must fit within that, any sentencing must fit within that range. Understand that? I see here that the plea agreement for you, Ms. Jennifer Gathright, is that you would be pleading guilty to that charge in exchange for the state's recommendation that your sentence be affixed at 10 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended and you being placed on community supervision or probation for a period of 10 years, that you would be fined $5,000, that you would pay $180 restitution, that the state would be dismissing 4 other charges, and you would be agreeing to a weapon forfeiture in this cause. In addition to that, you would have court costs and reimbursement fees and restitution. Is that your understanding of the plea agreement? And Mr. Gathright, your plea agreement looks to be very similar. Punishment would be affixed at 10 years confinement in TDC, suspended, and you being placed on probation for 10 years, also receiving a $5,000 fine, $180 restitution, and the court or the state would be asking the court to dismiss 2 other criminal offenses, and you would be agreeing to a weapon forfeiture in this case. In addition, you would have to pay court costs and reimbursement fees. Is that your understanding of the plea agreement? And both of you are asking the court to approve these agreements today. Is that right? All right. So Ms. Gathright, at this time, I'm going to ask you, how do you plead to the first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? Mr. Gathright, how do you plead to that same offense? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? The court will accept each of the defendants' pleas of guilt. Mr. Hyde, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted as State's Exhibit 1 in each case respectively. The court does take judicial notice of the defendant's judicial confessions. Is there anything further from the state?
No, Your Honor. Move the rest of the court.
From the defense?
Defense rests opposed to the case.
All right, the court's reviewed the evidence in each case. The court finds that there is enough evidence to convict Jennifer Lee Gathright and Kelly Wayne Gathright of the offense of manufacture, delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. Court will follow the plea agreement in each case. The court convicts Ms. Gathright of that offense. Court will assess her punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place her on 10 years community supervision. Court will order her to pay a fine of $5,000, restitution of $180, court costs of $290, and reimbursement fees of $35. Court dismisses under section 1245, DA 2020-1015, DA 2020-1016, DA 2020-1014, and DA 2020-1221. And the court orders the weapon to be forfeited. Cause number CR 21-118, court hereby convicts Kelly Wayne Gathright of manufacture, delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. Court assesses his sentence at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, suspends that sentence, places him on 10 years community supervision, orders him to pay a fine of $5,000, $180 restitution, $290 court costs, and $35 reimbursement fees. The court dismisses DA 2020-1019 and DA 2020-1018, and the court orders all of his interest in the weapon to be forfeited to the state. Do I have probation conditions? I have not seen those.
Probation training, Mr. Gathright.
Okay, thanks. Are we all right to fine on that one? That's Mr. Gath, that's actually Miss Gathrights. All right, Mr. Gathright, I'm gonna have you come forward to be fingerprinted with the bailiff. All right, Ms. Gathright. All right, is that all you have, Mr. Hyde? Thanks, sir. Appreciate it. All right, do we have anyone else that's ready, council? No. Do we have anyone else that's ready? Are we ready on Mr. Bruner? All right. We don't have any pleas that are ready. Is that right?
No, Judge, I believe that, the two cases, Ingram and, Jeff Sanders' case.
Okay. All right, Mr. Wood, if you'll approach. All right, we ready to go forward? Now I understand that you
Those qualifications are that person who is a psychologist testifying or participating in such matters should have education history consistent with the expectations of CEU credits, hours toward meeting the standard, which you understand rather low, 6 hours per year, and I meet those standards plus with a considerable amount of experience in the federal court system, federal correctional systems, and the courts as well.
Are you aware, have you made, let me start over. You were appointed to assess Mr. J. Michael Bruder, is that correct?
That's correct.
And you submitted a report, I believe, March 31st of 2021 this year?
Yes.
Okay. And there was you were appointed for a second reassessment. You submitted a report to the court on July 8th of this year, is that correct?
That's correct.
Judge, we've asked that the court take judicial notice of Dr. Ingram's reports filed March 31st, 2021, and a reevaluation on July 8th, 2021. No objection.
Being no objection, the court takes judicial notice of Dr. Ingram's competency reports, March 31st and July 8th, 2021.
Doctor, you might review both of these reports. In both of those reports, what is your conclusion regarding Mr. Bruder?
Well, my conclusion is that he's competent to stand trial. That's the bottom line conclusion. And of course, there's several things I say in the report which led to that conclusion.
You may.
Dr. Ingram, you said there's a number of observations you made about this work.
Yes, that's correct.
And kind of, if you would, walk me through your evaluation process and the items of note that you observed regarding this work.
The process itself, I take the perspective, which is generally accepted standard practice, by the way, that one should look at multiple data sources when doing such assessments to determine which way the clinical evidence points, so that no one piece of evidence is considered to be sufficient. Instead of looking at one piece of clinical information, I look at several to see what's the predominant direction of the information and the clinical data that I have available. And I did that in this report, in the 2 evaluations actually. In both evaluations, I presented some scales which help an expert to determine whether a person has a factual understanding of court process. These are standardized measures where standardized questions are asked, and then responses are looked at and assessed by evaluator, in this case by me, to determine whether or not a person factually understands how to the court process, whether he or she understands how to work with the attorneys, whether he or she understands the role of the judge, understands consequences of being found guilty, understands plea bargaining, would be able to comprehend that at a basic level. And also some of the scales are helpful in determining whether or not someone is feigning lack of knowledge of the court, to look at the question of the possibility of lingering. So all those measures were part of that evaluation. There's 2 evaluations. Plus, in this particular case, I went beyond that and administered MMPI 3 and also the SIRS, which is standardized and gold standard for looking at the issue of attempting to label symptoms. In addition to those scales, I conducted clinical interviews of the gentleman here and spent considerable time with him. The first time I think I interviewed him was about 60 minutes or so. And the second interview, the second evaluation was quite lengthy. It's actually a total of 3 hours, not the interview itself, but a portion of that 3 hours was a clinical interview, as well as talking with the jail staff. Nurse in question at the jail, I looked to them to tell me what the person's behaviors were like in the jail environment, which I did under both circumstances of the evaluations, talked to the nurses there, or nurse that is. Also, I made a point of talking to the family. My concern is that I have multiple different sources, and some of them will disagree with my findings, perhaps some of them will not. I don't attempt to cherry pick information that supports some biased position that I have. I try to let the data speak to me as strongly as it can. And when it can't, I'm going to indicate that it doesn't. But on the other hand, when the data points in a certain direction, I'm going to indicate that it does. And that's what I've done in this particular case.
Okay. And what is generally Mr. Bruner's attitude and behavior to you during these evaluations? Is he combative? Is he cooperative?
His behavior was uncooperative at points, in particular in the first evaluation that I did, and also in the second. He would talk to me, he would answer my questions, but there was a guardedness about his answers. And there were statements that he would make that I would then check out and discover were false. For example, he said that he had never been before the judge before. I believe the defense counsel had pointed that out in one of his write-ups to me. So I set a certain experiment up, took him from the jail proper to a room where the video cameras are, and asked him, have you ever been in this room? Oh yes, I was here when I was in court. Well, he had said earlier to others that he didn't remember ever being in court. He'd also claimed to, I believe his defense counsel or others, I'm not sure it's on that point, that there was a conspiracy to kill him in the court, or kill him in the jail. And I checked that out again with him at a different time to ascertain whether or not this was some kind of delusional problem on his part, fear of paranoia of being attacked, or whether or not there was someone actually plotting him. And I wasn't going to investigate that, but I was going to ask him about that, which I did. He had told his family that they were going to kill him in jail. And when I asked him about that, he denied it. Again, giving false information to one party to obviously make some type of impression upon them, and at the same time, when I would ask him about it, he'd say no. So there was this split between the information he was giving various parties, some of which contained considerable lack of candor, if not outright falsity.
How would you, in your expert opinion, how would you describe, is that an indication of competency, or is that an indication of lack of competence?
It's an indication that it could be, under certain circumstances, an indication of lack of competency if a person was clearly psychotic. That's an important distinction. If a person is not psychotic and acting that way, then the most of the evidence points in the direction of trying to be misleading, guardedness, lack of cooperation. And I would say that since I saw no clear evidence of active psychosis, and neither did the nurse, and neither did the practitioner who came in to give him medication for depression, nobody could see psychosis. So there was no evidence to support that I could find clinically. Also, he recognized me every time I saw him. He knew who I was. And, all of these factors point to the fact of lack of cooperation, guardedness, false statements, and competence. To be able to do all of that, one has to have an intact brain. If you're psychotic, you can't do that to the degree to which he was doing. Also, you cannot answer on the psychological question, particularly in NPI 3. He did not show a pattern that was indicative of a person who was confused, who perhaps was psychotic. It take a very thoughtful person to answer in the manner that he did.
Is that the test that he answered all false to, or is that, no, that was the service to?
That's correct.
Did he answer every question false?
That's correct.
Is that indicative of an organized thought process with just being uncooperative, or is that indicative, in your opinion, of something else?
It is indicative of a person who's thoughtful, who's not psychotic, who's able to answer questions, who is deliberately, willfully answering false.
So basically, and I don't want to put words in your mouth, obviously, your conclusion is that he's competent, but basically lingering lack of understanding of at least certain aspects. Is that correct?
No, it's not. It's not. The use of the term "notice my report" never says the linger.
Yes, sir.
I don't say that this is a malingering. I say that this is guardedness. Now we're going to discuss diagnosis because it plays directly into what you're saying. I have diagnosis this gentleman as having pervasive depression, alcohol abuse, and a paranoid personality disorder. And those in combination, the guardedness has to do with distrust. It doesn't necessarily have to do, it doesn't have to do with psychosis. Psychosis would be a different problem. This is a deeply ingrained personality component for this gentleman who's been present for decades. Made worse when he's abusing alcohol. And he's had a long history of abusing alcohol and explosive violent behavior. And individuals with paranoid personality disorders, if they're going to abuse substances, they're going to be explosive, they're going to be attacking, they're going to be suspicious. And even when they're not abusing substances, like now, for example, there will be suspiciousness that will be ongoing, which will lead to this pattern that I described.
Judge, I have no further questions.
Mr. Wood?
Sure. Dr. Jeff Wood, by the way, it's great
Yes,
to
sir.
meet you. We've talked on the phone a couple of times, obviously not in the room. And in addition to that, we actually had a conversation outside right before this hearing.
Yes,
Appreciate you being down here.
yes, sir.
Kind of walking us through. I can tell you, I've been doing this for 12 years now. This is kind of the first time that I've been through this situation. And the situation, quite frankly, is that respectfully, I somewhat disagree with your outcome. So I kind of want to walk through your reports. Because I think, in my opinion, when I was reading your reports, I was thinking one way, and then at the end of the report, I was kind of shocked to see that the outcome was that this person was competent. So obviously, you talked about and talked about evaluating Mr. Burns twice. So the first thing you talked about the first time you evaluated. You said that you talked to his family, his mother, and his ex-wife, correct?
Correct.
Do you have the evaluation report in front of you by chance?
Did I have the evaluation?
Do you have the evaluation in front of you right now?
Yes, sir.
Okay, so you can refer to it if I'm talking about it. I just want to make sure so that I'm not putting words in your mouth and that you can refresh your memory.
Okay.
You have to do so. Essentially, you say that
Which report are you referring to?
I'm referring to the first one, which is the one that was conducted on March 5th, if I'm not mistaken. You mentioned that you talked to his mother and his ex-wife. I'm curious to know, because I also have been in communication with them on a regular basis. And also have had an opportunity for them to express their concern regarding Mr. Bruner's mental state and psychotic nature. I'm curious if they explained that to you.
They explained concern regarding his behavior. They did not explain psychotic behavior as you stated.
Let me kind of switch real quick. Your, I think, opinion is that there is a difference between somebody who is has a mental disability and diagnosable mental disability versus, I think your word was psychosis. What is your definition of psychosis?
Well, the DSM-5 lays out diagnostic criteria for psychosis. And I can't cite every aspect of that diagnostic criteria, but I can sum it up by saying the following. Psychosis is a mental state where an individual is unable to determine reality from fantasy, where there's confusion, where a person is likely to be having a variety of very bizarre symptoms, including delusions, hallucinations of various kinds. The person may also have very strange ideas about things. I mean, there's a whole list of strange ideas, or they can have some symptoms associated with strange bodily complaints, very bizarre statements associated with health. We can also have some very, very extreme and paranoid delusions, beliefs that individuals are out to get them, and have very complicated ways in which they look at that. All of which would be looked at as irrational, would not make a lot of sense, wouldn't certainly meet the common sense test, let alone a diagnostic test of sanity. A person would be unable to make good judgments. Their judgment would be impaired. They would not do well in terms of problem solving. They would often have a very bizarre history. That's in summation.
So is it your opinion then, Dr. Ingram, that the only way that somebody can be deemed to be incompetent would be that they also show signs of psychosis? Is that your opinion?
I'll ask you to repeat the question.
Is it your opinion that the only way that, in your mind anyways, in your opinion, that somebody can be deemed incompetent, meaning that obviously we know the definition of competency, but incompetent only if they showed signs of psychosis?
A person diagnosis in and of itself does not determine competency versus incompetency.
Right.
It's true that a person who would be psychotic, there would be serious questions as to their ability to make judgments, cooperate with the attorney, to be able to factually and rationally understand the process, and so on. So there would be strong evidence in the direction of incompetence if they were psychotic. Yes.
But wouldn't you agree with me that there are also other mental disabilities that clearly prevent somebody's ability to rationally discuss facts or circumstances surrounding maybe their case or their environment, et cetera, simply because they have a mental disability, correct? Say paranoid schizophrenia, for example.
Well, that's a form of psychosis.
Okay, say, in this case, I think you diagnosed Mr. Bruner with, I'm not mistaken, paranoid personality disorder with antisocial traits.
That's correct. That is not psychosis.
Right. But again, you would agree that one does not have to be in a psychotic or a psychosis state of mind to be deemed incompetent. There are other avenues in which an individual. There are other avenues in which an individual can be deemed incompetent, correct? Besides just being, in your opinion, under a psychosis.
The bulk of people who are found incompetent often have a very serious mental disorder. Not infrequently, they have psychosis. There are other disorders where a person may have problems making decisions. But the bulk of people that are incompetent have some serious psychiatric disorder that's having to do with schizophrenia or having to do with some form of psychosis.
Okay.
By far and away.
In your opinion?
I think the data, research data supports that the bulk of people who are having problems with competency and have serious mental illness also have some form of psychosis. It could be a bipolar disorder with psychotic features, it could be some other things.
Sure.
But usually there's some kind of psychosis involved.
In your report, obviously you discussed the family history, and right off the bat, you state in your report that clearly Mr. Bruner was not responding openly to your questions, correct? That he was being uncooperative.
Yeah.
And you kind of in your report, you give quotes, which I kind of smiled when I saw. And does that indicate that those were the answers that Mr. Bruner was giving you, really short answers to your questions, essentially?
If you would refer them to what.
Sure, it's going to be on page 3. I mean, if you don't mind me reading, it says he describes his family as being, quote, all right. And it's right after that you explained that he clearly was not responding openly to your questions.
Mm-hmm.
So is that the type of uncooperativeness when you talk about a simple, really short answer to the questions that you were asking, essentially?
I never draw a diagnostic conclusion based on a single incident of anything.
Okay, so it was the entirety of the,
That's correct.
basically the entirety of the interview, he was uncooperative. Correct.
He was guarded and uncooperative.
And again, you say again, there was poor cooperation in his education history where he says he just lost interest. He didn't remember being expelled or anything like that. You again, attribute that to mainly just being uncooperative instead of any type of mental
That's
or
not
memory
correct.
issue, correct?
That's not correct.
Well,
The uncooperativeness is due to the paranoid personality disorder. I wouldn't consider that to be just pure uncooperativeness. When a person is uncooperative, we have to decide what's the possible basis for this uncooperativeness. Some people are just uncooperative because they don't want to.
sure.
They're not ill. They're making a conscious, deliberate choice, and then they're not suffering from any kind of mental health disorder.
Okay.
He has a mental health disorder. I'm not denying that.
Okay.
I'm saying what he has is paranoid personality disorder. Which
So you're saying that his uncooperativeness is not by his choice per se, but by his actual mental diagnosis of paranoid disorder.
there's always a choice involved.
Sure.
With every mental disorder, There's always a choice involved. You cannot say that mental disorder destroy the ability of a person to make certain choices. Unless they're so deranged and so out of touch and so psychotic, which he isn't, that they're so impaired to the degree they cannot make a choice. They're insane.
I think a good way of looking at it is maybe spectrum.
Pardon?
A spectrum.
Yeah.
Fair enough. I mean, you have somebody over here that's extremely psychotic, if you will, unable to make any decisions on its own.
That's right.
And then maybe you have somebody more in the middle that kind of floats along that edge every now and then. Would you agree? Maybe at times you make rational decisions, and other times, for whatever reason, no.
There's a spectrum.
Sure. In talking to his ex-wife, she explained to you, according to the report again, that he was a suspicious type person, and which would go to show, obviously, his paranoid disorder, correct?
Yes.
And when you again, I'm sorry.
Long term.
Long term.
Yes.
Exactly. All right. Then when you talk to Mr. Bruner, he mentioned to you that he'd been married a couple of times and he didn't remember. And again, you noted again that was an indicative of poor cooperation rather than actual memory problems. Like,
I don't think he had that. That's right.
just not cooperative.
Again, because of the paranoia, lack of cooperation is a part and parcel of that particular difficulty. So a person who has that disorder will just be inclined to try to deny almost all kinds of things.
Sure.
You know, were you married? Oh, no. You know, how long were you? Well, I don't know. I mean, there will be a lot of denial or refusing to answer simple questions that most of us are answering.
I'll make a sidebar, Doctor. I know exactly what you're talking about when it comes to Mr. Bruner and those kind of responses.
Yes, I'm sure you do.
The thing about Mr. Bruner, though, again, you know, that he has a long history of psychiatric care. This isn't somebody that has not been in psychiatric treatment before. In fact, I think you laid out that from 2017, as a matter of fact, all the way to 2020, he was at least at sometimes treated through the Andrews Center here in Canton. Correct. And they, I guess, had diagnosed him with some sort of major depression with psychotic features.
I saw that. Yes. Also, I'd like to add to that.
Sure.
What I also said after having said that diagnosis is in reviewing the records from the Andrews Center, which I did for the period of time that you mentioned. The individual who did the last note after Mr. Bruner was incarcerated made the point that at no point during the treatment had they seen symptoms of psychosis, which undermined, in my view, again, I'm very careful about this, undermined the diagnosis of having a psychotic disorder. So the record shows that they did diagnose him as having major depression with psychotic features, but then proceeded to sort of undercut their own diagnosis by saying they didn't see much evidence the whole time they were until the end of
this year. Yeah. Which to elaborate on that, I think that you know too that the individual who evaluated Mr. Bruner in that particular situation wasn't sure how to make. In fact, your exact words is, "I am not sure." He was not sure what to make of this.
Well, he went on to say, if you read the full quote, he went on to say that there was only vague statements made by Mr. Bruner, and that, you know, that tells me psychosis, if it's really a true psychosis, you don't have to worry about vague statements. You don't have to worry about that because there will be enough bizarre and strange comments. You don't have to worry, oh, a vague statement. A vague statement is clinically inconclusive. Okay.
You then went through the scale, the rating scale. On Mr. Bruner.
Yes,
And I won't go through all of it, but I will hit the high points. Obviously, you gave him, and there's a numbered scale, correct?
yes,
And then it's 1 through 7, 1 being the least severe, 7 being the most.
yes,
And you mentioned in there hostility that you gave Mr. Bruner a 3 and indicated mild to moderate underlying hostility, correct?
yes,
Suspiciousness, again, you gave him a 3, which there were indications of mild to moderate underlying suspiciousness. But then, again, you go back to this no psychosis. But then on uncooperative, you gave him a 6. In fact, you labeled his uncooperativeness as being grossly uncooperative.
yes.
How does being grossly uncooperative begin? I know there are a number of things which you evaluate. Does being grossly uncooperative throughout an evaluation affect the actual evaluation?
Uncooperativeness always has to be understood in the light of the clinical data presented. It does not invalidate the evaluation. It is something that has to be explained, which I have explained in my report as to why he was uncooperative. Now, the suspiciousness, I did 2 separate evaluations, as you know.
Right.
And in the second one, I tend to evaluate on the conservative side. I don't give people high numbers on this stuff. So I thought, well, maybe there's something going on with this man. And, so I didn't rate suspiciousness as high as I probably should.
Sure.
Should have been higher in the first.
Well, and I think it's, under current diagnosis, in fact, during the first evaluation, you don't diagnose them with paranoid.
That's correct. I
Right.
didn't. And that was a conservative approach on my part. But when certain questions were raised by you as counsel, I felt an obligation to Mr. Bruner and to the court to do a much more in-depth look at suspiciousness and other aspects of this case, and which I did do, and I think my second report indicates that.
And I'll get to that one in just a second, for sure. But again, you talked about this test, Mr. Woodwhite kind of brought it up too. Mr. Bruner was not able to be, really not able to be much help regarding that test due to the fact that he was, again, vague responses, if I don't know, false responses. So that test is kind of a wash in your evaluation.
I would consider it a wash. I would consider it an indication of lack of cooperation, which is far from a wash. It's part of the pattern.
Sure. Okay. Of having this paranoid.
Yeah, being suspicious, being guarded, giving insufficient information.
So you make inferences, obviously, based on your report, correct?
So
You make inferences based on your
inferences, yes.
inferences, yes.
Yes.
And obviously you did in this report as well. And the first one I highlighted, and,
On the
which
first
you say,
report,
you're on page 9,
okay,
in which you say Mr. Bruner most likely has an acceptable factual understanding of the court process. Now, that's your statement, most likely has an acceptable factual understanding. Dr. Ingram, isn't it either you have an understanding of the court process or you don't have an understanding of the court process?
given his response patterns and styles and guardedness and the way he presented himself, I was not convinced he was psychotic. I was convinced that he was lacking cooperation, and that from my evaluations of him, I felt that he was most likely that he understood what was going on.
He was never able to tell you, though, that he understood what was going on, obviously, because he was uncooperative.
I would suggest that rather than able to tell me,
Or I would suggest,
he
okay,
didn't tell me.
fair enough. He didn't tell you because, again, we're not saying that Mr. Bruner, though, is being uncooperative due to the fact that he's just being uncooperative. You made that very clear that he's being uncooperative because he's got a psychological and a or psychosis disorder, but at least a paranoid disorder.
Paranoid personality.
Paranoid personality. So it's not a lingering type situation. It's simply that,
It's not one. No.
sure, he's got a paranoid disorder. You then say that regarding his courtroom behavior, that he is capable of conforming his behavior to the expectations of this legal process, and that he is unlikely to disturb the court process with bizarre behaviors and explosive speech. That was your inference back on March the 5th, correct?
Yes.
And you came to that inference after.
Pardon?
How did you come up with that inference?
Well, if a person is psychotic, unable to control their behavior, there's evidence of that in the clinical interview. There's evidence of that in the jail environment. So given the fact there was an absence of such behavior and such disorganization in either the clinical interview or in the jail environment, I hypothesized that he could control his behavior and that he could participate in the court process without being disrupted. And I might add, he's doing a good job right now.
Sure.
Yes.
Would it surprise you, know, because I think that's why we had the second evaluation done, right? Because there were outbursts, if you will, bizarre behavior in a court proceeding, granted not in this particular courtroom, but at the jail, sometime between the March evaluation and then the time at which both not only myself, but the state of Texas also believe that competency again can become relevant, and that's why we asked the court in this particular case to reevaluate this. It was primarily because of those bizarre behaviors in which he was displaying. Right?
I would review the videos of the court hearing that you're referring to. I saw on the current course certain behaviors, had some Kleenex in his ears, also did not look at the court, look at the judge, looked around. These kinds of behaviors, when you use the word bizarre, bizarre is a very powerful term. I wouldn't use the term bizarre to describe that behavior. Yes, it's unusual behavior. Yes, in certain respects, it shows something of lack of proper behavior, but it's far from bizarre.
In your opinion? Because
I understand
bizarre
you
means somebody shows up.
All right, gentlemen, so she can't type down what both of you are saying at the same time. So you are going to have to one at a time.
The other inference that you make in that first report, again, that's concerning to me, obviously, is that his ability to disclose to counsel pertinent facts, events, and his states of mind. You say in response to that, he's able to disclose pertinent facts, events, states of mind in this case to his attorney in a rational manner. How did you come up with that?
Because he was not in a psychotic state, because his behavior was workable, and because he was showing he had a rational component to his thought processes, that he could answer questions, that he could provide information to you or to the court, whoever would ask those questions. So I concluded that he was capable of doing so. That sets aside whether he was willing to do so. and whether or not he's somewhat suspicious
based on his disorder
based on his history and mind.
and what had occurred throughout that evaluation, which was
Yeah.
his
Yes.
uncooperative with you. But you were still able to make that inference, that even though he was uncooperative with you, based on his disorder, that he would then be able to be cooperative with his attorney.
Uncooperative is not equal to competence. It equals lack of cooperation.
Sure.
That has to be explained, which I think I did explain.
But in the definition of competency, Dr. Ingram, is one's ability to consult with his lawyer with a reasonable degree of rational understanding. If an individual is uncooperative due to the fact that he has a paranoid disorder and is unable to cooperate with his attorney in a reasonable degree of rational understanding, that then meets the definition of incompetent under our law, correct?
If he's actually unable to do so, yes.
Sure. Well, that is the situation here with Mr. Brewer.
I don't think it is the situation. I think there's paranoid components to his thinking. I think he can cooperate. That is not to say he does not do so without suspiciousness, but he can cooperate. In my estimation, he can.
How then does he choose? Well, because you note in there, in the first report, that medication, in the first report, I think you say regarding medication is psychotropic medication plays no significant role in helping to maintain his current level of competency to stand trial. You, I guess he just picks and chooses when he becomes cooperative and uncooperative. Is that your opinion?
Did I pick and choose one?
He picks and chooses when he becomes cooperative and uncooperative.
There's always an element of decisiveness in Mr. Brewer, deciding what to do, what not to do, deciding what answers to give, deciding what questions to respond to. In terms of paranoid personality disorders, psychotropic medications do not erase that component. So while medications can be also helpful, it doesn't necessarily erase this suspicious tendency.
So you don't believe that medication is helpful?
I never said that.
Well, in fact, you said the opposite in your next, which was done obviously in June 21st and June 25th.
I suggested in my first report on the role of medication that he's not taking the psychiatric medication, given its history of current symptomatology. Psychotropic medications play no role in helping him maintain his current level of competency to stand trial. Because of the personality components, I thought and still think he is competent. The medication would not necessarily affect that competency at that point.
Okay. In the second evaluation, obviously, that was done, and I won't go through it in its entirety, obviously, because quite frankly, it was for the most part similar to the first evaluation. Regarding this uncooperativeness, is you again label his uncooperativeness as being grossly uncooperative on page 11. You give it a 6 on a scale from 1 to 7. So again, in evaluating him the second time, several months later, he still is uncooperative, except this time, based on other information, obviously, probably that you received from me and other individuals involved, you rate his suspiciousness as a 5 instead of I think it was 3 or 4. Yes, right. And his hostility is still a 4. But for the most part, the same type of uncooperativeness that he showed during the first interview, he showed again in the second correct?
Yes.
But at this time, I think you've already hit on it, determined that uncooperativeness was not based upon the fact that you simply, I use the term generically, me, but because you, at this point, actually diagnosed him with paranoid personality disorder with antisocial traits. If you have obviously it's clear that if you have a paranoid personality disorder, antisocial traits, you are grossly uncooperative, correct? You can't. For obvious different reasons.
He was uncooperative.
I think we labeled, and I think that the record's pretty clear, that his uncooperativeness was a result of his paranoid personalities.
And choice, yes.
Now, where do you get choice at?
Well, simply because, not simply, even a person with a paranoid personality disorder can make conscious decisions to cooperate. So it's not as if a paranoid personality disorder, say you want a can of Coke, why you give it a can of Coke. And a person can decide, yes, I'd like to have Coke, without it being an issue. So there is a rational component that remains. A person is not totally completely absent of the capacity to make decisions because they have a paranoid personality. But what is there is shall we say, the bent toward denial, the bent toward uncooperativeness, that kind of thing. Suspiciousness is present.
And again, that affects, at the end of the day, in some capacity, one's ability to.
So does choice.
Choice is in everything.
I understand it.
Right. People with paranoid schizophrenia, somebody that is under a psychosis state of mind, would you agree they also have a choice in certain situations? If
Yes.
somebody, I'll put it to you this way, if somebody is paranoid schizophrenic and yet they are on medication, don't they have a choice?
Of course.
They stop taking their medication, Dr. Ingram, and that choice becomes, in a way, cloudy, and they then are unable to make that choice. Does that automatically mean then that they are deemed and have to face?
So there's a difference between clouded judgment and no judgment, and no capacity to make decisions. Our people who have mental disorders have some problems in making decisions, depends on the disorder, and it depends on the severity of that disorder also. But the capacity to decide is present in most people who have mental illness.
But mental illness affects that.
Well, I'm not denying that it doesn't affect. The issue is that does it affect to such degree that a person is incapable of? That's the issue. Not whether or not it has an influence. It always has an influence.
But it also would be a relevant factor in one's inability to be cooperative, correct?
And that's what?
It is a relevant factor in one's inability to be cooperative, correct?
It's a factor.
Sure. And it's also a reason why somebody may be grossly uncooperative. Was the case?
It could be, but it's not always. It has to be clinically determined. And I understand that there's some differences of opinion on this.
Well, you made the opinion. It's your opinion that the reason why he was grossly uncooperative was because of his paranoid personalities. That's your opinion.
That was his choice. There's the disorder and then there's the choice. These two go together. He does, in my view, from my assessment, have paranoid personality disorder. But that does not destroy the capacity of choice. It is present in this gentleman. He chooses to do certain things, while at the same time being suspicious and uncooperative. We cannot boil this down to simple understandings of mental illness, nor simple understandings of choice.
Because it's not black and white, correct? There's a large gray area.
There are gray areas, yes.
Mr. Woodward.
Very briefly, Dr. Ingram, on, I believe it is the second one. In the inference section, something that stood out to me is that he spoke to you at one point, this is in the section regarding plea bargain specifically. He said he relayed to you that he would accept a plea bargain, quote, anything that would let me out of jail.
That's what he said.
That's what he said, okay? And the court will recall, and I believe, I don't know if Mr. Wood was present for this, but the court had a conversation with Mr. Bruner that if he would cooperate with the process, at that time, there was an offer of probation, i.e. he gets out of jail that day. If he would just cooperate with Mr. Wood and go through the proceedings and act in a cooperative manner.
No.
And at that time, he seemed to have there was a flicker of understanding, oh, okay. And then he immediately just turned around and walked away from the court, who was still trying to communicate the process to him. Isn't that in some way indicative of a lack of understanding of this process, or is that a symptom of just this gross suspicion, even of the courts?
I don't take that necessarily as indicating a lack of understanding. This gentleman has at least average intellectual functioning, and is not impaired in an intellectual sense.
Sure.
So understanding of it, I don't believe is an issue. I think he did understand it. The larger understanding that I see in the behavior, walking away and not agreeing to accept the plea bargain, it sounds very counterintuitive. Why would anyone do that if they were rational? I would say that in a case like this of Mr. Bruner, there's an oppositional defiant component of anger that goes with the personality disorder that I've mentioned, where a person will shoot themselves in the foot, so to speak, will refuse to cooperate in ways that leave people wondering what in the world is going on and how can this be? People would jump at the chance to cooperate, so to speak, because of the obvious benefit. These individuals will oppositionally refuse to do so while being rational. And it looks as if someone is like, wow, this person must not understand, or they must be so impaired that they can't see the actual information, that is, they're irrational. That's not true of someone with paranoid personality disorder who has a strong rational component, but also has a paranoid component, and can choose, but sometimes he elects not to choose that which is sometimes in their best interest.
Mr. Wood, any additional questions?
I don't have any.
All right, thank you, Dr. Ingram. You may step down. Mr. Woodwide, do you want any argument?
Just state that.
Mr. Wood? No argument to the court? Yeah, argument.
With all due respect, Doctor, I disagree. I think Dr. Ingram, Bruce, is conservative, and that's fine. Problem is that when you are able to diagnose somebody with a paranoid disorder that essentially, by its definition, creates a situation where one is uncooperative due to that disorder. And then in the same breath, say what that person has a choice to be this way. It's counterintuitive in my mind. I don't understand. Either you have a paranoid personality disorder that affects your ability to be cooperative in a lot of situations. And that then takes away that choice. And I think that's exactly what we have here for Mr. Bruner. Mr. Bruner is not malingering. Mr. Bruner is not, which I've never believed. I've never believed in my communications with Mr. Bruner that he's been malingering in this process. Malingering, in my 12 years of practicing criminal law, in my personal experience, when I see somebody that's malingering, usually that malingering aspect disappears when a favorable disposition occurs in their case. It's a miraculous thing, but it happens. Mr. Bruner's situation is quite the opposite. Mr. Bruner wants out of jail. Mr. Bruner doesn't understand anything that's really going on in any type of communication that I've had with him. Yet when the state of Texas offers Mr. Bruner an opportunity to get out of jail, and I convey that to him, he's still uncooperative. He's still paranoid. He still has antisocial trust issues. And that's because he is not competent. He is not competent to stand trial. He cannot communicate in any rational way or reasonable degree of rational understanding. I've yet to see that happen out of this. And that's explained. Now, on the record, it's explained. Not because he's malingering, because he has a paranoid personality disorder that at this point in time has not been treated. And that's what we're asking the court to do, is to give significant role and I guess credence to the fact that Mr. Bruner has this disorder. He does. Dr. Ingram says he does. But give credence to that and understanding of why it is that he's being uncooperative, and the issue of why he's being uncooperative is because he's not been able to seek treatment for that. And that's what I believe needs to occur here at the end of the day. I believe that he needs to be deemed incompetent so that he can seek the treatment for this particular disorder, personality disorder. And in the hopes of once that occurs, that paranoia diminishes to the point to where he becomes cooperative. And he understands what's going on. And he can communicate with us, and we can resolve this issue accordingly. But right now, it's not able to be done. So that's what I'm asking for.
Didn't Dr. Ingram though touch upon medication, and that in his opinion, he didn't believe that the medication was going to remove that?
First, and I failed to bring this up, but if I could, in his second report, he mentions this. He does. Now, I wouldn't say a 180 on this because I think he does. There are some distinction points, but essentially, he does say that psychotropic medication plays a helpful role in helping him with his moderate depressive symptoms. So instead of not playing a role in anything regarding his competency now, after the second evaluation, it does.
And what did it say affected though? Did you say depressive?
Well, his moderate depressive symptoms. Given his history and current symptomatic presentation, psychotropic medication plays a helpful role in helping him with his moderate depressive symptoms.
I don't recall hearing any testimony though about how depressive symptoms interacts with his paranoid or antisocial. Do you have any comment on that? What I kept hearing Dr. Ingram say was that medication is not going to affect his antisocial or his paranoid personality disorder. That medication's not going to affect that, but that he doesn't believe that he is to the point of not having rational ability to make a decision on whether he wants to comply like he has today versus other times when he hasn't complied. So that's where I'm kind of stuck.
I'm not a psychiatrist, Judge. I don't, I won't portray myself as being, nor am I a doctor.
No, and I understand that, but I'm saying, so Mr. Bruner gets locked up and he never gets out because medication is not going to affect his personality, his paranoid personality trait is what I heard, is the medication is not going to remove that. And if he's always antisocial, if he's always suspicious, and medication is not going to affect it.
Well, I don't know, Judge, because again, in the first forensic evaluation report, Dr. Ingram in that report did not diagnose Mr. Berger with paranoid disorder.
Well, but I think his response is that he didn't do that until he was asked to.
Right, and then he came up with the conclusion that in fact, there is a disorder that meets Mr. Berger's situation, that he's not being lingering in a sense, he's simply has this disorder. My argument would be that medications for those particular types of things are out there. That's the purpose of the Andrews Center, and that's the purpose of those particular types of hospitals to at least at least try those medications to see if those medications do work. Because let's say somebody's paranoid schizophrenic. You could argue that in that particular case, the medication doesn't work. Sometimes it does. Sometimes it does clear the mind of that individual to the point where they are at least able to rationally discuss their case with their defense instead of being completely 100% uncooperative, which is where we're at right now.
But are you talking about psychotropic medications for, and I don't want to spend too much time talking about paranoid schizophrenic because that's not what he's been diagnosed as. So I don't want to talk apples and oranges, but his opinion was that the psychotropic medications are not going to remove his antisocial, suspicious, paranoid personality issues that govern him to make a decision. That's what I heard. Tell me if that's not.
Well, either way, I mean, the point is, I think Dr. Ingram testified the reason why he's uncooperative, not just with me, but with the system, with him, with everybody, is the fact that he has this disorder. The fact that he's not able to cooperate with me and explain situations with me and understand situations that are before him with a reasonable degree of rational understanding, it puts him squarely into the definition of being incompetent. And that's really what we're hearing. He's incompetent. He's incompetent, in my opinion, because of this disorder. So, in my opinion, the question is, does he just remain incompetent? Or can he be treated and via some sort of medication that controls that paranoid disorder to the point where that uncooperativeness isn't absolute? And I think that's the question.
Mr. Woodward.
Judge, to be clear, I have no idea what to make of this.
Well, that's okay. Then I don't want to hear anything else. If you're not going to offer anything else, that's fine.
I find it difficult to parse Dr. Ingram's. He is fully capable of making decisions, particularly when we're discussing plea bargains at the end. He's fully capable of doing this, but because of this, he will make decisions that are not in his best interest. That seems to me as though he is not competent to make decisions that are in his best interest. That sounds like incompetent to me, but the way he described that is though he still has this rational ability to make a decision that is clearly against his own self-interest seems incompetent to me. A lot of what Dr. Ingram says makes a lot of sense. I just don't know how to parse in this particular situation with Mr. Bruner, that he is making decisions that are against his self-interest, that he can still be competent. I have no idea about Mr. Bruner's communications with Mr. Wood. I can't possibly. I trust Mr. Wood when he says he cannot have rational, reasonable communications with Mr. Bruner. I trust that completely. Mr. Wood has zero reasons to lie about that.
Yeah, I don't think that's an issue. I think it's clear to me that the testimony of Dr. Ingram is that the man has a paranoid personality disorder.
Yes,
And that causes him to be antisocial. It causes him to be suspicious. I mean, that's clear. He's saying that does not make him incompetent, because within that, he still has the ability to make a decision on how he acts and how he responds and what decisions he makes.
I would agree. I think that is exactly his opinion. I don't think that's necessarily incorrect.
And so
what my understanding is that he makes rational decisions within this paranoid, uncooperative framework against his own self-interest. I'm not sure if on a legal basis that meets the definition of competence.
but you would have to agree with me that every day this court entertains plea bargains and rejection of plea bargains where people who are not suffering from mental health make decisions that are against their best interests. And that does not mean they are incompetent. You both have to agree with
I would
that.
agree. Sure.
They know what the facts are. They've been communicated to them. They have rational thought, rational understanding, and they make a decision that's clearly not in their best interest after being advised by counsel, perhaps family members, others. That does not put them into an incompetent state.
Sure, but Brian.
Those individuals haven't been diagnosed with a disorder.
No, I understand. I'm responding to Mr. Woodwag. He says he doesn't understand how that could be, that what Dr. Ingram's testimony is that he can't make a rational decision because when it's presented to him, he shoots himself in the foot. I'm saying people shoot themselves in the foot when they commit offenses and they have rational thought. They shoot themselves in the foot throughout their litigation. They shoot themselves in the foot at rejection. So I'm responding to that. I'm not saying that he doesn't have it. I'm saying his expert opinion says, right? He's the doctor. He's the one that says that, yes, he has these things, but not to the level that he doesn't have a rational understanding of the charges against him, that he's not able to make a decision as to whether he wants to help you. I mean, have you ever represented someone who just didn't want to help you, that didn't have mental health, that was uncooperative, but didn't have mental health?
Absolutely, but that's not the case.
I know, but
I'm not here to evaluate other people.
I know, but my point is you've had other clients that are uncooperative. You've had other clients that don't want to participate in their defense.
Absolutely.
Doesn't make them incompetent.
Right. But I've also had people that have been uncooperative with me and not want to participate in the defense and not understand the ways in which the legal system works. And those people have found incompetent.
Right, but Mr. Bruner's not been found incompetent. So I think what I'm going to do is I'm just going to order another evaluation, and we'll get another disinterested expert. And if it comes back the same, then I guess we'll conduct another hearing. And at some point, the court's going to have to go forward. He's either going to be found incompetent or he's going to be found competent. Right now, I'm finding him competent. Right now, on your suggestion that you disagree with the expert's opinion, you're not asking for him to be reevaluated. I'm just going to sua sponte, order him to be reevaluated. I think you may have suggested that previously. I'm going to do that. If he comes back with the same diagnosis and the same expert opinion, I'm going to grant another hearing for you to contest that. And then the court's going to make the ultimate decision on whether we go forward with the reports and the finding of competency. So it's going to take me some time to find another expert that's willing to do this work for the court.
Sure.
At what the court can afford.
I'm appreciative of that recommendation. I think that's.
All right, so the court's going to reset Mr. Bruner. We're going to set Mr. Bruner on January 4th for a status of the third competency evaluation. And I'll have Ms. Abraham send you notice of who the appointed expert's going to be with a copy of the order.
Thank you, Your Honor.
Probation. Ms. Bird's not. We're talking about the probation officer. This is probation. I don't know. I need to hear from the state on that. All right. Thank you, Mr. Bruner. You may have a seat. Mr. Williams. I'm sorry, Mr. Harrell. You're free to walk to the back with the officers. Yes, thank you, Mr. Wood. Mr. Harrell, Mr. Sanders. This is cause number CR 21-263, State versus Justin Wayne Harrell. God, we're set for a status today. Is this in regards? I'm not sure what this is in regards to. Is it pretrial release?
Your Honor, yes, the state filed a motion to hold the commenced bond insufficient based on some information police have provided. Probation has today, I think that there are what they believe to be additional violations of this pretrial release conditions. Ms. Clark was on her way over to testify about this.
Okay, and has that been provided to Mr. Sanders?
Yes.
Okay, all right, Mr. Harrell, at this time, I'm going to place you in the jury box and order you to stay there until your hearing is concluded. If you need to use the restroom, you'll contact the bailiff and we'll make arrangements. Ms. Heisel, is she like literally on her way?
There's only two people present. There's departments that they just asked if she will have to.
Yeah, she said she was going to talk to me about it, I thought. So yeah, ask her if she'll talk to me. record. All right, court calls, cause number CR 2140, CR 21344, State versus Terry Glenn Vance. We're set for evidentiary hearing today on Mr. Sanders' motion to suppress evidence. Go ahead, Mr. Sanders.
And Judge, today, as far as the case where you have filed the motion to suppress, we would just state that we don't see a need at this point to move forward on the suppression hearing because of the new felony charge. I just didn't want to lose the opportunity to have a suppression hearing if for some reason it was necessary later on down the road. I just don't know that it is going to be necessary because of new, more serious charge. I didn't see a need to spend court's time on that today with this new charge.
Have you already conducted a waiver of arraignment with Mr. Vance? I showed he's set for arraignment.
Right, I haven't yet, and I can actually, if the jail let me talk to him before the docket this afternoon, I can get him to sign a waiver.
Yeah, I'm not sure if they will or not. I don't know. It's lunchtime for them over there.
So
So
much have to bring him over for that purpose anyway, but
I didn't realize he was set for arraignment on charge as well.
I think we just put him on there just because of the.
Because of,
anyway,
that's fine, that's fine. He was just indicted on a new charge. State's opinion is that we are comfortable with allowing Mr. Sanders to leave his motion to suppress pending. We don't believe it'll likely matter much to the overall outcome of Mr. Vance's both cases, given that the new case is a higher charge with a larger punishment range. We anticipate that the old state jail case will likely be subsumed into the new case. But we're comfortable with letting Mr. Sanders allow that to pen for at least a period of time at the court's pleasure and convenience.
all right, court's going to allow Mr. Sanders to carry his motion to suppress to trial, but I do not want to hear it at trial. So if we're not going to reach an agreement in this case, I'm going to ask counsel to call my coordinator and get that set on an evidentiary hearing day rather than taking up time when the jury's in the box.
Absolutely.
With regard to arraignment, I'm going to ask that you within a week meet with Mr. Vance and execute a waiver of arraignment, and your pretrial date will be December 14th. Do you have any scheduling issues that day?
No, I don't think so. It'd be the afternoon.
If he's in jail, then. So I'm going to notate my docket in the record that you're going to file a waiver of arraignment after meeting with Mr. Vance. And we'll set that new evading charge for pretrial on 12/14. And we'll carry the PCS lesson 1 on docket call of even date. And then if you need a hearing, you'll let us know and we'll get that scheduled.
Do you have discovery on the new charge? Yeah. Okay, I will make sure that for the record, I will make sure that it's done. Hopefully I will get the copies and break to you this afternoon.
Okay, yeah.
Thank you, Judge.
You're welcome. Thank you, Sanders. All right, Ms. Clark, are you ready? Ready, Ms. Heisel? All right, Mr. Harrell. We'll come down here and have a seat with Mr. Sanders. This is cause number CR 21263. Go ahead, Ms. Heisel. All right, Ms. Clark, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
So see. And then just go ahead and move your seat up so you're closer to the microphone so my court reporter can see you. And then speak up loudly, clearly, and let's not talk over one another. Go ahead, Ms. Heisel.
Thank you, Robert. Ms. Clark, are you currently employed by the Madison County Supervision Department?
Yes, ma'am.
And what is your job title and your responsibility?
I'm a community supervision officer and I supervise individuals placed on pretrial release and on probation.
And Justin Carroll, is he on your pretrial release caseload at this present time?
Yes, ma'am.
And do you know the date he was placed on your caseload?
Maybe. I believe it was on 6/2/2001.
Okay. And Mr. Harold, do you know what offense he stands charged with?
Sexual assault of a child, I believe.
And is one of the conditions of his probate, or excuse me, of his pretrial release that he wear a GPS M1?
Yes, ma'am.
And when was that M1 installed?
6/2/2001.
And since that point to this present day, how many violations have there been on that GPS M1?
He has had 5 shutdowns since it's been placed on him.
So there have been no geographical infractions on that unit.
Okay.
But it has shut down 5 times, you said?
Yes, ma'am.
And if I have in front of me that one of these occasions, this unit was shut down for a little over 30 minutes. Would that be accurate with your records?
He's had the maximum time of shutdown is 2 hours and 39 minutes.
Okay. So with those violations, what was the shortest amount of time that it was shut down before it was reactivated?
17 minutes.
Okay, and those dates of violations, could you provide me with the dates of each of those 5 violations?
On 6/11, it shut down for 30 minutes. On 6/14, it shut down for 29 minutes. On 7/6, it shut down for 2 hours and 39 minutes. On 7/29, it shut down for 17 minutes. And on 10/1/2001, it shut down for 36 minutes.
Did you have conversations with Mr. Harrell about charging his unit such that this shutdowns would not occur?
Yes, ma'am. I had conversations with 2 other officers that had conversations.
So is it fair to say he's had multiple warnings about the recourse violations on the unit?
Yes.
And since October the 1st, has he had any additional violations on his unit?
Since October 1st, no.
Since October 1st, has he had any other violations of his pretrial release conditions other than GPS infraction?
Yes, ma'am.
And what is that?
He tested positive for methamphetamines on October 12th.
And was that collected as a order of the court or just as a standard condition of pretrial release?
It's a standard condition of pretrial.
And on the 12th, so he submitted to the UA, is that correct?
Yes, ma'am.
And then did the UA come back as a presumptive positive?
Yes, ma'am. Officer Crawford collected his UA because I was out at lunch and he had to use the restroom at that point in time. So Officer Crawford took him to the restroom and he tested positive on the in-house test. It was sent off to the lab for confirmation on that day.
Okay. And was it sent off to the lab for confirmation because he did not use it?
I'm unaware of that.
Okay. And that lab report did come back, is that correct?
Yes, ma'am.
Your Honor, may I approach?
You may.
Ms. Clerk, I'm going to show you what's been marked for purposes of this hearing. It states Exhibit 1. Do you recognize this document?
Yes, ma'am.
And what is this?
This is the lab confirmation we received back from the lab with positive results.
Okay, so this top sheet, is this your sheet provided to the lab?
Yes, ma'am.
And then the subsequent 3 pages of the lab's confirmation of that. Is that correct? Your Honor, at this time, I offer State's Exhibit 1 into the record.
Any objection? All right, State's Exhibit 1 is admitted.
Your Honor, I have no further questions.
Mr. Sanders?
Thank you. Mr. Clark, has Justin taken any other drug tests during the time since he
I'm not sure.
and you weren't present whenever there was the drug test taken to if there was any explanation or admission or anything like that.
And that's something that's on.
And so is it just standard to go ahead and send drug test results to the lab to be confirmed?
If an individual denies usage, we send it off for confirmation.
As far as the GPS unit is concerned, he said that they hadn't had any issues since around October 1st. Is that right?
Yes.
And in looking at the documents that the state had provided to me, whenever the instrument shuts down and then turns back on, will it show the location of where the unit is?
It will show the location of where they're at that point when it turns back on, but it will not show the locations he's been during the shutdown.
Okay. And so it doesn't show, like, if it's, like, basically, if, for example, if it shuts down, he's home, and then 17 minutes later, or 30 minutes later, it turns back on and it's still home, will the information you get, will it show that it shut down and when he was at home and it turned back on?
It will show where it shut down at,
So,
wherever he's at, and it will show where it turns on at, wherever he's at. But where he's at in between, it will not show.
right, okay. To your knowledge, was there ever any time whenever the shutdown occurred, he was at home and it turned back on and he was not at home, or vice versa?
I don't know. I didn't check that.
Okay. And to your knowledge, at least on the June 11th, June 14th, and July 6th, and those were all early morning or fairly early morning, whenever those shut down.
What dates?
June 11th,
That was at 3 in the morning,
okay, and then June 14th was about 7:30.
7:59.
And then July 6th, it turned back on about 3:49 in the morning.
Those were the clear times, I apologize. Yes,
Okay.
those are the times that they cleared, where they turn back on.
And I think you testified to, really, just to clarify, there hadn't been any issues with him being outside of the range whenever the GPS has been working.
No.
And whenever the instrument shuts down, it's just because it hasn't been fully charged.
Because it has been charged appropriately.
Okay. And so basically it's just the battery's dead, it has to be recharged.
Yes, sir.
Okay.
Faisal, any additional questions?
No, Your Honor.
Thank you, Ms. Clark. You may sit down. Any further evidence, Ms. Faisal? Mr. Sanders, any evidence?
No.
All right, any argument, Ms. Faisal?
Your Honor, the state is going to re-urge the motion to hold bond insufficient. In this matter that has previously been filed, we believe that Mr. Carroll's violations, both his GPS unit and his closet UA, show that he is danger, especially, Your Honor, considering the 2-hour and 39-minute shutdown. A lot can happen in that time period. That gives us quite a bit of concern. We would ask that the bond be held insufficient, he be taken into custody. And Your Honor, I don't off the top of my head remember what bond amount I requested in my motion, but I would agree with whatever I previously requested.
Thank you, Ms. Faisal. Mr. Sanders?
As far as the GPS is concerned, I don't think there's any indication of any evidence of the testimony or the reports that we received where he wasn't at home whenever the shutdowns occurred. I know that specifically that July 6th shutdown time period was about 2.5 hours, 2 hours, 40 minutes. But again, that was early in the morning. I believe it would have been from about 1:09 to about 3:50, 3:49. That Ms. Clark had stated. And that was back in July. Judge, it looks like from everything I was provided at least as far as August and September went, things have been going well. I know there was with the GPS system, October 1st, I think that was the one violation with the GPS system more recently. But otherwise, he had been doing well with that. I think part of it, a lot of it's just either not understanding or not focusing on what he has to do to make sure it stays charged. But we think that he's done well, and the main violations were months ago, and it's been doing well with GPS, other than this October 1st issue. Judge, as far as the drug test goes, I know that's probably the bigger problem, or at least a big problem. And Judge, he denies that he had taken meth. That's why the lab was used in this case to confirm that. Judge, what we would ask is that his bond not be revoked or found insufficient, but that he remain out on bond, and if the court sees fit to impose other conditions as far as more frequent drug testing, going to some kind of a beginnings program or some kind of outpatient treatment in the meantime, whatever the court sees fit, but we'd ask that his bond not be found insufficient or revoked, that he be allowed to stay out.
Thank you, Mr. Sanders. All right, based on the evidence presented to the court is going to find that Mr. Harrell has violated conditions of his pretrial release. Court's going to find that he did not maintain the GPS device as instructed and ordered. Furthermore, the court's also going to find that he has violated his pretrial release by testing positive for methamphetamine. Court hereby holds his bond to be insufficient. Court hereby orders him to be reincarcerated in the Van Zandt County Jail, and the court will set bail at $200,000. So Mr. Harrell, stand up, please, sir. You might want to wait a second. You can follow, I mean, you can follow him, but you might want to let him de-escalate a little bit. All right, Mr. Ashmore was walking back there to provide something. Mr. Sanders, do you have anything else on this morning's docket?
Not this morning.
Sorry to ruin your day, sir. Thank you, Mr. Sanders.
I'll be back in a second.
Okay. Well, what do you have this afternoon? That's Jason Cravey. Okay. Well, do you want me to have your client brought over, Vance, or do you want to wait and do the waiver agreement? I've already told him not to bring him.
Yeah, that's fine.
Okay. All right.
It's safe.
Okay. Okay, we'll do that. Appreciate it.
In fact, I may even see. I should probably have to go over there just to carry this on the way.
Okay. Mr. Ashmore and Ms. Heisel, can we meet on Ms. Fowler?
Yes, Judge.
I hate to hold you over till the afternoon. Do you have any afternoon hearings?
I'm here for y'all, Judge.
Are you, yeah, you have other afternoon hearings?
We have a couple of pleas on MTRs are going to resolve today.
We're right at the lunch hour,
No.
so I was gonna go ahead and break, but y'all don't have any kind of agreement on Ms. Fowler, do you? We still need a testimony of Dr. Ingram.
I mean, I think we're in agreement. I don't know that we are in agreement with with Dr. Ingram.
Yeah, it's going to be very similar
Or are y'all gonna be asking for another?
for a different evaluator. I know you might need to hear testimony about, there's a written objection. But we're prepared to offer testimony. I could do that with an offer of proof.
No, I'll tell you what, don't worry about it. I'll just do it. I'll just reevaluate. And then if it comes back the same, then you can always bring both of them back if you wanted to. So is she already set for something else?
It's just this.
No, I mean, is she set for another date already to where we don't have to bring her up?
We're kind of in docket call floats until this is resolved, because there was a partial evaluation and then some miscommunication as to whether she had COVID. She had a respiratory infection, but not COVID. And then the second didn't get, the conclusion or the second meeting didn't happen with him. And now we're here because he went ahead and issued a report, which we think is not thorough enough.
All right, I'll tell you what, let's reset her till, are you fine doing, I know you're not gonna be at 12:02. Can I set at 12:02? That's our next evidentiary.
Yeah.
Well, after that would be, she's on bond, so
And she's doing good.
it'd be late January, maybe January 27th before we have the next
I
evidentiary.
think let's just go ahead and set it for 12:02. We'll see how the reevaluation comes back. I'll discuss with Mr. Ashmore if we need to agree to reset it.
Let's do this. Let's set it for 12:14. You available
I'm on, I
12:14?
think I'm already.
And we'll just do a status on that one. And then I've got to go find another doctor to get the second opinion, so. All right, so, Ms. Fowler, if you'll come up, please. Here, go ahead and fill one of these out, Casey.
Yes.
Put 12:14 on there, have her sign that. All right, Ms. Fowler, we're not going to get to your hearing today. So what I'm going to do is I'm going to reset your case until December 14th. But what's going to happen in the meantime is I'm going to have you meet with another doctor, okay? And I want you to cooperate with them, okay? I want you to stay throughout that whole examination. I want you to listen to what they have to say and I want you to cooperate, okay? And we'll send that information to Mr. Ashmore about who that will be. And then he'll give you that information and they'll call and set up a time, okay? Yeah, I'll get with him. So just like you know. Just what I do to say.
Well, that's really all my exact and his pants. I guess we gave her to him this morning.
Was he, all right, court's going to stand in recess until 1:30. We'll broadcast on YouTube.